Okay, ladies and gentlemen, I'm back again. This is Chukuma Odelogo. I'm trying to see if I can continue to comment on public policy issues, but I want to zero in mostly on the judiciary. And I've been talking about the Supreme Court. And the last two videos, I talked about two bad ideas floating around about how to cure the Supreme Court of its many ills. And the first one I discussed was decentralizing the Supreme Court. I said that it was a very bad idea. The second thing I talked about, oh yeah, states having their complete set of courts, from their magistrate courts all the way up to state Supreme Courts. And then, of course, the federal government will have its own, the national government, I should say. I want to, as I do these videos, I will get into federalism. And I will talk about terms, appropriate terms, like using the word federal. You see, the word federal actually means a combination of both the national government and the state governments. That is, and its subnationals. But so it's a better description or better terms for the government in Abuja is the national government. And of course, the states are the subnationals. The national government and the subnationals together make up federal government. That's why you hear that a geographical entity is a federation. That is the national and the subnational, but that's by the way. Let me get to the point. That I want to discuss particularly today, I digress too much. I want to discuss particularly today another bad idea that's been floating around with regards to the Supreme Court. That bad idea is the idea that if you keep increasing the number of that with increases in the number of cases at the Supreme Court, that the cure is increasing the number of justices at the Supreme Court. Intuitively, it sounds great. That is, if you increase the number of cases, you just increase the number of people who handle them. Actually, that's not a good idea. It's a very, very bad idea. In fact, as we speak, I believe the Constitution provides for 21 justices at the Supreme Court. The 21 justices are too many. There are too many. What you need, the optimum number of justices that should be at the Supreme Court. Remember, the Supreme is one. The optimal number, the ideal number is a number that allows them to sit as one. It could be 7, it could be 9, it could be 11. Of course, it's preferable to be an odd number, but it should be a number that allows them to sit as one. When you have 21 justices, it becomes unwieldy. They cannot sit as one. They now have to start sitting in panels. And once they start sitting in panels, they create that very problem that they are supposed to solve. That is the purpose, one of the critical purposes of the Supreme Court is to reconcile the circuits, is to reconcile the different divisions of the courts of appeal. But when they start sitting in panels, they start sitting like glorified courts of appeal. Instead of 3, they're now 5, but it's still the same thing because they're now sitting in panels. And the tendency for different opinions will start coming up, and you now need what? Another level of court system above them to reconcile the differences. You know, it gets rather complicated and actually rather interesting. In the United States, this is what they do. With a similar system, this is what they do. In the Court of Appeal, the Court of Appeal, they sit in threes, just like they do in Nigeria. 3 judges, 3 justices. They sit in threes. Like in the DC Circuit, for example, they sit in 3 judges. If you file an appeal from U.S. District Court to the DC Circuit, you get 3 judges. Now, those 3 judges, after they have reached a decision and given a decision, if you're dissatisfied with that decision, you have 2 options. One is to appeal to U.S. Supreme Court, which we discussed earlier as being it's almost a waste of time, because it's rare that the U.S. Supreme Court will take your case, and there are no appeals as of right to U.S. Supreme Court. So what happens is that there is a provision in the U.S. called sitting en banc. Sitting en banc is, rather than appeal to the U.S. Supreme Court, you appeal to all 13 judges that sit on the DC Circuit. Now, what does that do? Those 13 judges that sit on the DC Circuit can actually hear your case. Now, why do I bring it up here? With 13 judges sitting in DC Circuit and with you getting 3 judges sitting in your case, there are 10 other judges that may have a different opinion about that particular issue. Among that 10, you may have several panels that may have reached different conclusions from the one reached here. And now when you call in those judges, what you do, you increase the chances of those other judges outvoting the judges in your current case, and you get a different outcome. Now, sitting on back, they'll read your petition. If judges vote to hear it, they'll hear it. And in many cases, they do. Your chances of getting an en banc sit are far, far higher than going to the U.S. Supreme Court. But we don't have sitting en banc in Nigeria. For instance, in the Lagos Division, if 3 justices rule a certain way, you can't call on the rest of the judges in the Lagos Division to participate in your case. I don't believe that there is such a procedure in Nigeria. That's something that can come. Nigerian Supreme Court needs to get away from most of these cases. But again, I hope I've not deviated again. That the major point I'm making in this video is that the idea of increasing the number of justices on Nigerian Supreme Court in order to increase its efficiency is bad. That in fact the 21 justices you have there are actually too many justices. You don't need that many to do what the Supreme Court needs to do. My name is Chukwuma Odeluga. I'm a lawyer. Let me stop here for today. I'll be back with more videos. If you like, share these videos, like and share them. They might not be the best, but they'll get better. Encourage me. Thank you.